Hello, and welcome to the Minnesota Association of Townships Matt University. Today we'll be continuing our series on township roads. Specifically, we're going to be covering vegetation control. Today we'll be covering the statutory tree and vegetation removal process. We'll also cover mowing. Finally, we'll cover some issues which can be created by Minnesota's endangered species laws. For those who are interested, we'll offer some additional resources for further reading. Let's begin with the statutory removal process. The statutory tree and vegetation removal process is found in Minnesota Statute 160.22. Now in that statute, townships have their own special subdivision. That is Subdivision 10. The 2023 version of that subdivision is posted on your screen now. Let's break that statute down into its component parts. In general, we have the right to remove trees or other vegetation within the limits of any town road, even when we don't own them, so long as they either interfere with the maintenance or reconstruction of the road or interfere with the safety and convenience of the public. However, there is a process that town boards must go through to exercise this power. It begins with a determination. The first step is to pass a resolution declaring the township's intent to remove trees, hedges, shrubs, vegetation, etc. within its right-of-way. The next step is to send written notice to the adjacent landowner or renter, if there is one, that the town will cut specifically described and marked vegetation in the right-of-way, and that they have 14 days to request a hearing before the town removes that vegetation. The notice must tell people that they have the right to have a hearing, and must tell them how to get one. If no hearing is requested, you can go ahead and cut. Be sure to keep all the documentation from each step of the process in case you need to prove that you went through that step later. Also be sure to leave the lumber on the landowner's property unless you have written permission to do something else with it. Of course, if they do request a hearing, then we've got to go ahead and have one. At the outset, we should note that the hearings in this case will be also governed by Minnesota's open meeting law. Now, we won't be covering the open meeting law in detail in this presentation. We'll save that for a separate Matt U presentation. Specially governing this hearing process, though, are Minnesota Statute 160.22 Subdivision 5 and Subdivision 6. The 2023 version of those subdivisions are on your screen now. In essence, before we cut, we have to set a time and a place to have a hearing. The owners and the renters have to be giving written notice at least 10 days prior to that hearing. They have the right to be heard about why their trees or vegetation shouldn't be cut. Then after the hearing, we have to reduce our findings to a written order. Either we find that the owners were right and that we won't cut, or that they were wrong and we do have to cut. This resolution must be reduced to writing and served upon the owners, along with a notice that we have come to a determination. Here it's important to note that you can't cut immediately after making that determination. Minnesota Statute 160.22 Subdivision 7 grants landowners a right to appeal these determinations. They have a 30-day timeline in which to do that. So once you've made the determination that the vegetation does indeed interfere with maintenance or the safety and convenience of the public, you have to wait 30 days after the landowners have received notice before you can go ahead and cut. So breaking down this process from the beginning, the first thing that you have to do is to pass a resolution declaring the township's intention to remove trees, hedges, shrubs within the town right-of-way. The next thing we have to do is to send written notice to the adjacent landowners or renters that the town will cut specifically described or marked vegetation, and that they have 14 days to request a public hearing. If no public hearing is requested, we can go ahead and cut. If a public hearing is requested, we must have further steps. In particular, we must set a date for the hearing and send written notice to those landowners at least 10 days before the hearing. Further, once we've had our hearing, the town board must pass a resolution making a determination regarding the vegetation. We must send notice of that determination along with the accompanying resolution to the affected landowner or renter. Then finally, we must wait 30 days before actually removing the vegetation to allow the landowner or renter time to appeal the township's decision. Of course, tree removal isn't the only vegetation control issue that affects townships. What about mowing? Is there any statutory limit on our authority to mow our roadsides? There is. Minnesota Statute 160.232 provides the basic outline. Townships can cut or mow the right-of-way only at certain times and for certain purposes. The first 8 feet from the road surface or shoulder may be mowed at any time, for any purpose, and at any height. Beyond that first 8 feet, the answer depends on the calendar. From July 31st to August 31st, we may mow the entire area to any height. From August 31st to July 30th, we may mow only for safety reasons and to a minimum height of 12 inches. There are exceptions to that basic architecture. The first and most important exception is for safety. A right-of-way may be mowed as necessary to maintain sight distance for safety. Minnesota Statute 160.232 in parens D. The other major exception affecting townships is that relating to noxious weeds. Now, this one comes from a different statute entirely, but road authorities must cause all noxious weeds on their respective highways to be cut down or otherwise destroyed as often as may be necessary to prevent the ripening or scattering of seed or other propagating parts of such weeds. The authority for that comes from Minnesota Statute 160.23. Our discussion doesn't end there, however. Minnesota's endangered species law can create complications for townships attempting to maintain their roadways. The basic law here comes from Minnesota Statute 84.0895 subdivision 1. That statute prohibits the, quote, taking, unquote, of an endangered species, which includes plants. Subdivision 2 of that same statute provides certain permissible takings. Relevant to townships, there are 3 important exceptions. First, plants on an existing public road right-of-way except for ground not previously disturbed by construction or maintenance. Second, noxious weeds. And third, the accidental taking of an endangered plant where the existence of the plant is not known at the time of the taking. Each one of these are an exception from the general rule that it is illegal to take an endangered species. Here it's important to note that taking without an exception or a permit is a misdemeanor, which is punishable by up to 90 days incarceration, up to a $1,000 fine, or both. Of course, much more can be said on all of these topics. For folks who are interested in more information, please see document TR 6000, Tree and Vegetation Control. That document includes, for your convenience, sample resolutions and sample notices designed to make the tree removal process as painless as possible. Thank you for your time and your attention, and have a nice afternoon.